All right, are you Vanessa Williams?
Yes, sir.
All right, I'm gonna create a breakout room for you to talk with your attorney, Mr. Gilbert here. Privately, no one's gonna listen or monitor that. At least on our end, I can't promise about Genesee. All right, so we're back on the record, the 53rd Circuit Court. And as a reminder, we are providing public access both in the courtroom and also online. And we have an arraignment in People v. Vanessa Williams. It's two file numbers, 25-71111 and 7112. I think I said too many ones there. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
And good afternoon, James Gilbert here on behalf of Ms. Williams.
All right, we're here for an arraignment in both files. Have you had a chance to review the charging documents with your client?
Yes, we have gone through the charging documents, and she understands what she's been charged with and wishes to waive the reading.
All right, and we'll enter a plea of not guilty on her behalf as to those charges. Is a forensic center referral requested?
It is not.
And I see you're signing some papers over there. Are you doing anything on the cases today? Or?
No, we're not. This is for another file. I'm sorry.
Okay, no worries. Estimated length of trial?
Probably 2 days on each one.
Okay. And Miss Williams, I see, is in the Genesee County Jail. Do you know why she's down there? And
she has some pending charges down there. However, she does have her next court date next month.
okay.
Vanessa, can you tell the court what your charges are in Genesee?
Yeah, there it's a possession. It's a possession of heroin, possession of meth.
Okay. All right, and here the 7111 is a possession case here, and 7112 is an absconding. All right. Set this for a docket call on February 10th.
Okay.
At 2:30 in the afternoon. And do we expect that Miss Williams will still be in Genesee County at that point in time?
I believe so, Your Honor. That'll bring me to, I'm going to ask for a bond reduction, but that case will still probably be going on in Genesee County.
Okay, so we'll allow Zoom appearances from Genesee County then.
This is where the tone of the courtroom shifts fast. The defense pushes for bond reduction, framing it as an opportunity for treatment and supervision. But the prosecutor reminds the court she absconded in 2 counties. Then the judge drops the hammer. He has no confidence she'll return. That single line seals it. Bond stays revoked. Authority, consequences, and zero hesitation.
Mr. Gilbert, go ahead.
The reason I was a little hesitant, Your Honor, is I was going to, she has 2 files going on, one in Genesee and the one here. She currently has a $50,000 bond on this file. We'd ask the court if the court would consider a lesser amount. Genesee, it's my understanding, would release her if the Sheboygan bond was a lot less. However, she would be on a tether, and she is currently going to be in the MAPS program, which I believe has Suboxone. It has other drugs. I'm not sure. I don't want to misquote which drugs it is to make sure that she does not use the narcotics or the heroin that she's been accused of.
Looks like in file 7111, bond was revoked in the district court because of her absconding, and then in 7112 it's been set, right?
That would be great.
Okay.
Yes.
Ms. Goodrich, your position?
Your Honor, she, at the same time she absconded from our case, she also failed to appear to her prelim in Genesee County, so was missing in that county as well. So I would ask that that request be denied.
Yeah, I think I'll go ahead and leave bond as set in 7112 and leave bond as revoked in 7111. Looks like, she absconded on this felony charge, and then, it's not like she turned herself in or anything. She was, in Genesee County Jail, and somehow we found out, and now she's arraigned on our charges from there. So I have no confidence if Genesee County lets her out that we're going to see her again. So we'll leave bond revoked. If she bonds out of there, we'll go get her and have her up here. All right, Ms. Williams, we'll see you on February 10th at 2:30 in the afternoon. All right, Mr. Jolette, can you hear us fine? I'm sorry? All right, we're not hearing you. Oh, you're muted. Let me see if I can unmute you, or if you have to do it. You may have to do it, but I don't know whether you need to.
Now watch how the courtroom pivots to a probation violation tied to another pending jury trial. This is procedural, but it matters. The judge isn't rushing. He wants the outcome from another county first. It's a reminder that cases don't exist in isolation. One charge can ripple into another. The court carefully balances jurisdiction, timing, and fairness before pushing the hearing out.
Say anything or not, so we'll check here in a minute. This is file 22-6490 and 6535 FH for continued probation violation hearings. The alleged violation is a charge that's been pending in Emmett County. Mr. Gilbert, what's our status here?
It's my understanding, talking with the prosecutor, that this his charge in Emmett County has been scheduled for a jury trial, and I believe we need to wait for the results of that to determine how to move forward.
Okay, and is that scheduled in February, do you know, or
Not sure.
do you have any knowledge about that, Mr. Filippo?
I do, Your Honor. Mr. Jolette doesn't know I'm here. We had a status yesterday.
Oh, do you represent him in Emmett?
I do.
Oh, okay. Do you know when the trial's scheduled for him? I presume you do.
Yes, April 21st, 22nd, 23rd, and 24th.
Okay. What do you want us to do, Mr. Gilbert?
I guess I would ask for the hearing to be pushed out until we have the results of that trial.
Okay. Any objection, Ms. Gittert?
No objection.
I guess I'm not sure when we run out of time on the probation or not. That wouldn't relieve us of jurisdiction to adjudicate the violation that's pending, but I can continue to April 28th at 2:30 then.
Thank you.
Right. All right, Mr. Jolette, I see you've been unmuted. Is there anything that you needed to say to Mr. Gilbert or Mr. Filippo about the adjournment here today, or are you all set?
No, sir, I'm all set.
Okay, you have a good day, sir.
Thank you.
Hear us?
Yes.
Great. Up next, we've got People of the State of Michigan versus Dennis Brengard. It's filed 2021-6092 FH. Counsel, you want to state your appearances, beginning with the people?
Good afternoon, Your Honor. Susan Dillon on behalf of the people.
Good afternoon.
Good afternoon, Your Honor. Attorney Daniel Groh, P48628 on behalf of the defendant.
All right, good afternoon, sir. And Mr. Brengard, Mr. Groh, you're appearing by Zoom from separate locations. Let me know if you need a breakout room at any time to talk privately. This is a continued status.
This is where the stakes quietly rise. A remand from the Michigan Supreme Court is no small thing. The issue? Alleged ineffective assistance of counsel. The new attorney admits he may have underestimated the workload, but pushes to move straight to an evidentiary hearing. This isn't routine scheduling. It's about whether prior representation failed. The entire conviction could hinge on what happens next.
Conference after a remand from the Supreme Court for this court to conduct a Ginther hearing on two issues involving alleged ineffective assistance of counsel. I continued it so that Mr. Groh, your substitute counsel, so that you could determine whether you wanted to go forward on your predecessor counsel's brief, or whether you wished to file a supplemental or I guess either a supplemental or a superseding brief on those two ineffective assistance issues. Have you had a chance to review the file enough to make that determination?
Well, Your Honor, I first need to apologize. I was a little aggressive in my estimation of my ability to get as much done as I expected to get done by this point. I think that was even the judge, I think Your Honor said, "Are you sure you want the next hearing that soon?" And I said, yes. But at the same time, Your Honor, while I haven't completed all of the due diligence that I intend to complete, it seems to me that the dissenting opinion from Judge Shapiro very closely aligns with the remand order by the Michigan Supreme Court, especially with regard to the first two issues covered by the judge. And really the essence of a Ginther hearing is that the factual record is not available, an evidentiary hearing was not heard, and that needs to occur. So while I would be happy to do something that would be very similar to Judge Shapiro's concurrence, I think the far more critical issue is to get the evidentiary hearing scheduled, and then I would certainly be happy to provide the court with a post-hearing brief that harmonizes what leave was granted upon and the testimony of anticipated witnesses, Your Honor.
Okay, so let me know if I'm understanding that rightly, that you'd like me to schedule this for the evidentiary Ginther hearing without the need for additional briefing at this time, and then at the conclusion of that hearing, I could invite further briefs if it seems appropriate. Is that what you're saying?
Yes, Your Honor.
Any objection to that approach, Ms. Dillon?
No, Judge, I think that's fine.
Okay, so Mr. Groh, how much time do you believe that you would need for the Ginther hearing? I'm not asking how soon you want it. I'm asking how many days or half days do you think that you would need?
I think it would be appropriate to set aside a whole day with the goal of not using the whole day, but having it available.
Okay. Ms. Dillon, do you concur that setting this for a full day evidentiary hearing is our best next step?
I think so, Judge.
Okay.
Now, Your Honor, I must interject one more time, if I may.
Yeah.
All right. When you think it's simple scheduling, the defense attorney reveals they're preparing for a 3-week murder trial with over 40 witnesses. That changes the temperature instantly. The court now has to weigh preparation time against procedural urgency. It's a glimpse into the pressure attorneys juggle behind the scenes. Serious cases colliding on the calendar at the highest level.
I have a murder trial with some 40-odd witnesses scheduled for March. The court in Berrien County has set 3 weeks essentially for that trial to take place, taking up most of the month of March, and obviously leading up to the beginning of March will be a very compromised period of time for me, because I'll be devoted to trial preparation almost exclusively for that matter. So I just wanted to throw that out there before we started looking at dates.
Okay. Well, that means you probably don't want one in mid-February for 2 reasons. One, would be pretty close to where we are now, and maybe a little too close to that trial in March for you. Is that right? Yes,
Your Honor, regrettably. The timing's awkward. I appreciate that.
Okay. Okay. I believe that I could give you Monday, April 27th, if that gives you enough time at the conclusion of that trial to be ready to go on this.
Absolutely. And of course, trial counsel's availability that, he'll obviously is the primary witness for the Ginther hearing. I will contact him immediately, and I can contact the court immediately if he tells me he's starting a murder trial that day or something.
Okay. Well, why don't we tentatively schedule this then for an evidentiary hearing on Monday, April 27th, beginning at 9 a.m. That'll be in person. If there's any witness that either of you wish to testify by video, check with the other side and see. I require either a stipulation or a motion about that. Otherwise, I'll expect everybody to be in person for that hearing. Anything else you need me to do today, Mr. Groh?
No, Your Honor. Thank you very much.
If you find out that you've got any scheduling problem with either yourself or trial counsel, or any other witness, just contact Ms. Dillon and my assignment clerk, and we can get a phone conference with me anytime to talk through alternate schedules, okay?
Thank you. And just when we're off the record, are we off the record, Your Honor? I just wanted to talk
We're not off the
with my
record.
client very briefly before we ended the Zoom call. That's all.
You wanted to what?
Just talk to my client very momentarily if we're off the record.
Okay, I can create a breakout room for you guys to talk once we're all done, and then you can just leave the meeting when you're all done talking to them, okay?
Thank you very much, Your Honor.
All right, anything further on the record from you, Mr. Groh?
No, Your Honor.
Ms. Dillon?
No, thank you, Judge.
Okay, so Mr. Brengard, I'm going to create a breakout room for you to talk with your attorney. When you're done talking, you're free to just leave that room. We're not going to go back on the record in this case, okay?
This is a formal landing. The judge sets a full-day evidentiary Ginther hearing, in person, no shortcuts. Witnesses will testify, records will be examined, and the effectiveness of prior counsel will be scrutinized in open court. This is where accountability becomes structured and official. The path forward is locked in. If you found this breakdown valuable, make sure to like the video, subscribe to the channel, and we'll see you in the next video.